This is Bloomberg Law with June Grasso from Bloomberg Radio.
The music industry faced off against internet providers at the Supreme Court this week. At stake, billions of dollars, and specifically a $1 billion jury verdict against Cox Communications for not shutting down the accounts of customers who pirated more than 10,000 copyrighted songs by artists like Beyoncé and Justin Timberlake. The lawyers painted pictures of extreme consequences if the court ruled against their client. Here are Joshua Rosencrantz for the internet provider Cox and Paul Clement for the music labels and publishers.
The consequences of plaintiff's position are cataclysmic. There is no surefire way for an ISP to avoid liability, and the only way it can is to cut off the internet, not just for the accused infringer, but for anyone else who happens to use the same connection. That could be entire towns, universities, or hospitals.
If Cox is right on the law, then Cox could take tens of thousands of copyright notices and throw them in the trash, and they could have its employees say, F the DMCA. That is, in fact, what the record says, which is why they're asking you for an extreme rule.
The issue is whether internet providers should be held responsible for contributing to copyright infringement when they know their customers are pirating music but don't terminate their internet access. Some justices, like Samuel Alito, questioned whether forcing internet service providers to cut off infringers could affect institutions like hospitals or universities.
What is an ISP supposed to do with a university account that has, let's say, 70,000 users? What is the university supposed to do?
But other justices seemed skeptical that Cox had done enough to stop the piracy and questioned whether a ruling too favorable to internet service providers would allow them to ignore clear copyright infringement by their users. Here are Justices Sonia Sotomayor and Amy Coney Barrett.
You did nothing. And in fact, Counselor, your client's sort of laissez-faire attitude towards the respondents is probably what got the jury upset.
What incentive would you have to do anything if you won? If you win and mere knowledge isn't enough, why would you bother to send out any notices in the future? What would your obligation be?
My guest is intellectual property litigator Terence Ross, a partner at Katten Muchin Rosenman. Terry, explain the issue here.
The issue in the case involves process by which music companies, by music companies I really mean recording companies, track online sharing of musical compositions that they own the copyright in. The process allows them to identify the IP address and the ISP that is providing the service to that IP address. And so the music companies, recording companies regularly, on a daily basis, in fact, send notices of infringement to the ISPs that are providing the internet service to these infringers. And there are days in which they're sending out 10,000 notices to each individual ISP service. And the recording companies finally became fed up that the ISPs were not doing something. They wanted the ISPs to cut off service to these identified infringers. And the ISPs dragged their heels on doing anything, taking any real concrete action to stop it. And so the recording companies finally sued Cox Cable Company, which is one of the largest ISPs in the nation, alleging that they had engaged in contributory copyright infringement.
In its papers, Cox had argued that Grandma will be thrown off the internet because Junior visited and illegally downloaded songs. Did some of the justices seem to pick up on that concern?
There was only one justice who seemed to give some credence to that, and that was Justice Alito. He was the only justice who really seemed to buy into the position by Cox that it was hesitant to kick people off because of, and then you can fill in the blank as to what the reason is, they're a grandmother, they're a university, they're a hospital. In fact, the hypothetical posed at oral argument in the Supreme Court was what happens when all you can do is identify that the IP address belongs to a university. Are you going to shut down the entire university? One of those odd hypotheticals that takes the case to the extreme. The facts are actually contra to that. And indeed, none of the other justices seem to buy into that argument. The reality is that over the period of time in issue, Cox had received 163,000 notices of infringement and had kicked off of its service only 32 customers. The policy of compliance used by Cox was described in some detail, both at the Supreme Court and in the lower courts. And it was somewhat laissez-faire, to use the word that one of the justices used to describe it. They had originally started off and say, well, if we get 3 notices about a particular user, we're going to tell them we're cutting off their service. That rose gradually over time from being a 3 strikes, you're out policy to being a 13 strikes and you're out policy. And the 13 strikes reset every 6 months. So if you didn't get to 13 within a 6-month period, you went back to 0. Or if you got kicked off after 6 months off, you got put back on. They also capped the number of notices that they were accepting from recording companies at 300 a day. And then probably the worst fact of all, and which got brought up at the Supreme Court, if you could believe it, was the head of copyright compliance at Cox sent out an email to the people in charge of enforcing copyright policy in which he said, F the DMCA. F the DMCA. Now, the DMCA refers to the Digital Millennium Copyright Act, which is one of the key statutes at issue here, and which requires ISPs to set up a policing mechanism against copyright infringement if they want to claim the safe harbor that is embedded in the Digital Millennium Copyright Act. In response to that, one of the minions for the head of compliance wrote back saying, well, we're helping law-breaking customers. And there were dozens of emails like this amongst the compliance group at Cox that just manifested a complete disdain for copyright laws, which obviously impacted the jury because the jury below had awarded $1 billion in damages against Cox. And in the Supreme Court argument, it was clear that outside of Justice Alito, none of the 8 other justices were buying what Cox was trying to claim was their reason for not cutting off people, that you'd kick grandmas off of the internet. The other 8 justices just didn't buy it, and it was a loser argument for Cox.
So then can you tell where most of the justices do stand?
That's always a tough question. In this case, I think it's tougher than most. I think outside of Justice Alito, the other 8 judges were just incredibly skeptical of Cox's excuses for allowing this widespread infringement to go on. In the record below, there's apparently one period of time at which 21% of all traffic on the Cox internet connections, 21% involved copyright infringement. And the lawsuit below didn't go after, every single mom and pop business or every single college student. It was targeted only at distributors, not people who were downloading the occasional song, but people who were copying music digitally and distributing it on a mass scale. So there was this enormous skepticism expressed by the justice, except for Justice Alito, that Cox really wasn't fulfilling its obligation and needed to do something differently. Now, on the other hand, there also seemed to be some concern about the size of the jury verdict and whether or not the actions of Cox were sufficient to constitute willful contributory infringement, which is what set them up for much larger scale of damages than if this had been found to be just ordinary copyright infringement.
So what's the standard that the justices would use here? Cox contends that under a 2005 Supreme Court ruling, it can't be held liable for contributory infringement unless it affirmatively fostered piracy or clearly intended to promote it. The music companies say it's enough that Cox new subscribers were using its service to download songs illegally.
The case on appeal to the Supreme Court presented two pretty crisp issues for decision. The first issue, which I think is where the real fight is going to be, is whether or not contributory copyright infringement required some sort of affirmative action by the defendant. The second question presented for review was whether or not willfulness required some sort of knowledge of customer infringement. Now, the problem with that second question, the willfulness standard, is that Cox had failed to object in the trial court to the instruction that the judge gave to the jury about how to find willfulness. So after the case is finished, all the evidence is submitted, and the attorneys have made their closing argument, and just before the jury goes into the jury room to make a decision, the judge reads to them a series of instructions as to what the law is. And one of those instructions will go something like, Sony Music Corporation here has alleged that the contributory copyright infringement was willful on the part of Cox. In order for you to find willfulness, you must consider the following factors. And typically, if a party doesn't believe the judge has stated the law correctly to the jury, they get up and they object. And indeed, they don't even have to do it at the time of trial. These jury instructions are sent out to the lawyers well in advance, and you file an objection with the court saying, we object to this, and give the court a chance to refine it, improve it, so that there's no objection. Here, the Cox folks, for whatever reason, failed to object to the willfulness instruction. And that means they waived any objection to willfulness and had really no excuse in their briefing as to why they did that or why they should be excused from that. They pointed to a prior case. This is a series of litigations here. A prior case that was styled BMG, Bertus Music Group versus Cox, also coming out of the same Virginia court. And in that case, they had objected to willfulness, and it had been overruled by the Fourth Circuit. But that case was not on appeal here. The case that was on appeal, they failed to object to the willfulness instruction. And in fact, the fact that they'd done so at the first trial but not the second trial sort of suggests that they knew they were supposed to do that and then failed to do it. So I just don't see question number two as being resolved in any way in favor of Cox. And indeed, I suspect the court won't reach it so that we will get no further instruction from the Supreme Court on what constitutes willfulness. I think the court is focused really on the position that Cox is arguing that contributory infringement requires some sort of affirmative act. And that, as they phrased it, they can't be a contributory infringer by providing internet service to one of their customers.
So then do you think that they'll send it back to the lower court with an instruction?
I just don't know what they're going to do here. I have to be frank. This is one of the more opaque oral arguments I've listened to. The other commentators have argued that the court might be looking for some sort of middle ground. Indeed, I think it was Justice Sotomayor commented at one point during the argument that the court was being forced to choose between two extreme positions. And in particular, Justice Sotomayor, who was very skeptical of Cox's position, but also didn't quite like the extreme argument being made by Sony Music Corp and the recording companies, seemed really perplexed as to what to do, genuinely perplexed. The problem the Supreme Court faces here is that the standard for contributory copyright infringement has been pretty well settled in this court for more than a century. As early as 1912, there was a case that involved mimeograph machines. If you remember those, they were pre-Xerox machines way of doing sort of a mass production being, a couple hundred. And there was a case in which a publisher sued a mimeograph company for knowingly selling mimeograph materials to a company that it knew was engaged in infringing copyrighted works by using the mimeograph machine. And the standard was set out there and has been repeated over and over since that time, 1912. And the standard is pretty simple. If you provide something that you know is going to be used by a person to commit copyright infringement, you've engaged in contributory infringement. And the past cases haven't spoken in terms of needing an affirmative act. Although one could argue, this did not come up at the Supreme Court hearing, that providing the internet service is an affirmative act. The Cox Company argued in the Supreme Court that that's not an affirmative act, but I think that's sort of a stretch. In order to try to get around that line of cases, the Cox Company argued that contributory infringement is really akin to aiding and abetting liability in the context of torts and criminal law. And that's a real stretch that I think is just dead wrong. It would give the court a way to get out of this dilemma, but it would mean the court would have to overturn half a dozen cases going back to 1912 for over a century and say, now they're not good law anymore. I don't see the court doing that here. So I just don't see question number 2 as being resolved in any way in favor of Cox. And indeed, I suspect the court won't reach it so that we will get no further instruction from the Supreme Court on what constitutes willfulness. I think the court is focused really on the position that Cox is arguing that contributory infringement requires some sort of affirmative act. And that, as they phrased it, they can't be a contributory infringer by providing internet service to one of their customers.
So then, do you think that they'll send it back to the lower court with an instruction?
I just don't know what they're going to do here. I have to be frank. This is one of the more opaque oral arguments I've listened to. The other commentators have argued that the court might be looking for some sort of middle ground. Indeed, I think it was Justice Sotomayor commented at one point during the argument that the court was being forced to choose between two extreme positions. And in particular, Justice Sotomayor, who was very skeptical of Cox's position, but also didn't quite like the extreme argument being made by Sony Music Corp and the recording companies, seemed really perplexed as to what to do, genuinely perplexed. The problem the Supreme Court faces here is that the standard for contributory copyright infringement has been pretty well settled in this court for more than a century. As early as 1912, there was a case that involved mimeograph machines. If you remember those, they were pre-Xerox machines way of doing sort of a mass production being, a couple hundred. And there was a case in which a publisher sued a mimeograph company for knowingly selling mimeograph materials to a company that it knew was engaged in infringing copyrighted works by using the mimeograph machine. And the standard was set out there and has been repeated over and over since that time, 1912. And the standard is pretty simple. If you provide something that you know is going to be used by a person to commit copyright infringement, you've engaged in contributory infringement. And the past cases haven't spoken in terms of needing an affirmative act. Although one could argue, this did not come up at the Supreme Court hearing, that providing the internet service is an affirmative act. The Cox Company argued in the Supreme Court that that's not an affirmative act, but I think that's sort of a stretch. In order to try to get around that line of cases, the Cox Company argued that contributory infringement is really akin to aiding and abetting liability in the context of torts and criminal law. And that's a real stretch that I think is just dead wrong. It would give the court a way to get out of this dilemma, but it would mean the court would have to overturn half a dozen cases going back to 1912 for over a century and say, now they're not good law anymore. I don't see the court doing that here.
Do you think we'll see the justices coming up with some sort of middle ground?
So it's a shame that Justice Ginsburg is no longer on the court. As you recall, June, we've had many conversations about her knowledge of copyright law and her ability to cobble together coalitions for positions under the Copyright Act that are actually quite pragmatic and useful. And I just don't see anybody either with that depth of knowledge of copyright law or the ability to do that sort of log rolling on this court. And so I think it's going to be a real struggle for this court to come up with some sort of middle ground, particularly in light of the fact that the law here is just so set for such a long period of time and fits exactly into the past case law and these sort of odd cases that Cox cited to the Supreme Court, including this recent gun distribution case, the case the Supreme Court decided recently where the gun companies were being sued for deaths in Mexico. And the argument was they were aiding and abetting this criminal activity. And the gun company said, well, we sold the guns to dealers in Texas, not knowing what they were going to do with them. And if anybody's contributed to them, but it's not us. We had no knowledge of it. And that case just doesn't fit here, either legally or factually. And yet Cox sort of bet a lot on that. I mean, it was almost as if they're saying, oh, hey, we cite to some case in which, the Second Circuit, which everybody believes in on the Supreme Court, that'll get us over the hump. It's just such a stretch that it, in fact, backfires. One starts to think, well, what's wrong with their case that's the best they've got?
And that's a question they didn't ask during 2 hours of Supreme Court oral arguments. Thanks so much, Terry, as always. That's Terence Ross of Katten Muchin Rosenman. Turning now to another Supreme Court case this week. The court considered the federal judiciary's role in asylum cases, and the justices appeared open to allowing courts to defer to administrative decisions on whether immigrants have shown they face harm serious enough to qualify for asylum. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. So asylum seekers can ask a federal appeals court to review their case if the Board of Immigration Appeals denies their asylum claim. This case is about the role of the federal appeals court versus the role of the Board of Immigration Appeals?
Correct. Basically, here's the issue. When a person asks for asylum, they have to prove at the end of the day that they have what's called a well-founded fear of future persecution on the basis of their race, religion, political origin, social group, things like that. One of the main parts of such a case, there's a presumption that if you have experienced what's called past persecution, there's a presumption that you will then have a well-founded fear of future persecution. So what does that mean? That means that people go into immigration court and they explain what happened in their country that caused them to leave. And there's cross-examination and the judge can ask questions. At the end of all of this, there's two determinations. One, did the person experience past persecution? And number two, was it on the basis of one of the protected grounds? So in this Supreme Court case, what happened was there literally was no dispute about the credibility of the facts raised by the foreign national, in this case, Douglas Humberto Urias Orellana, who said that he fled El Salvador after repeated threats and violence from a hitman linked to a drug lord. And he said that the drug lord shot his half-brothers and tracked and threatened his family. And so, since there was no dispute about the facts, there was not a factual issue that was being raised on appeal. Instead, the court said, I'm going to take all of the facts that you've presented today as true, and I'm going to say that they still do not rise to the level of the high level of this word persecution, such that we can say that you experienced past persecution, such that you would get the presumption of future persecution. So now, Mr. Urias Orellana then says, well, how is that possible? I would like to get review of that. And so when it gets to the First Circuit Court of Appeals, the First Circuit says we're going to defer to the Board of Immigration Appeals, which is the administrative court that decides this issue at the end of the day. We're going to defer to them and say that even though the facts are not in dispute, we still have to give some deference to their decision in terms of, let's say there's a scale and you're weighing it. How many pebbles go on one scale? How many pebbles go on the other scale? That even that determination gets some deference, that the federal courts can't just reweigh the evidence on their end and decide whether the facts that were undisputed in a particular case constituted persecution such that the person should win their asylum case. So that creates sort of a circuit split.
So the case goes to the Supreme Court. What are the justices going to decide?
The Supreme Court then has to decide, okay, what happens in a case like this where there's not a dispute about the actual facts, but there's a dispute about whether the facts, when you weigh them, there's quote-unquote significant enough pebbles on the scale. Does the foreign national win or do they lose? Can we reweigh that on our own? Or do we have to give some deference under some standard of deferential review? And so the foreign nationals obviously claiming there should be de novo review. The court should look at this and say, okay, were the threats here that were undisputed sufficient to say that that was past persecution? And the government says, no, the standard is actually much different. And that this is actually a mixed question of law and fact. And so you have to treat that with some type of deferential review. And so you had justices like Justice Gorsuch saying a reasonable fact finder standard as opposed to de novo review. And others wanted to weigh it even more deferentially, potentially, than even that, and say that basically if there's substantial evidence to support the determination of the lower administrative court, that's enough. So that would be even a broader deferential standard. And it appears as if really there's not a lot of excitement in the Supreme Court for having a complete de novo review of this process. So the issue is really going to be how much deference is given in these types of cases moving forward.
So, Leon, just to clarify, everyone accepts that the facts of the asylum claim are determined by the court below, the immigration court. So the only question is how the federal appellate court is going to weigh those facts?
Correct. So what the lower court said in this case was, yes, all these very bad and serious things happened to you, but when we put all those pebbles on the stone, they're not sufficiently weighty enough on the scale to actually constitute persecution for the purposes of winning your case. And then the question is, okay, when this gets to the federal court, can they literally reweigh all of that exact evidence and say, no, those stones do weigh enough to tip the scales in favor of the foreign national? Or are they stuck with, hey, if this is in any way defensible, we have to keep this decision the way it is? And it seemed like the Supreme Court did want to give more deference than rather reweighing all of the facts in the case, even if they're undisputed, to decide if they meet the legal standard of past persecution.
If the appeals court can't reweigh what the lower court decided, it's not much of a review, is it?
Correct. I mean, it would only be a review if essentially what happened was somebody goes into immigration court and they say, the government came in and shot me one time in the left arm because I'm a dissident, and then they left. And then 2 weeks later, they shot me in the right arm. And then 3 weeks later, they shot me in the left leg. And they said, you want this to keep going, or are you going to stop being a dissident? And then the immigration judge says, well, that doesn't seem like sufficient persecution. You only got shot 3 times. Maybe in a case like that, then the court would say, well, there's no way a reasonable fact finder could come to that determination that that wasn't persecution. Because then you'd have this sort of reasonable fact finder deference or some other standard like that. But it's not never will we review it. So they're not saying never. But as opposed to a case like this where they're saying, okay, with threats, how serious are the threats? Were the threats very serious? They might say, look, this is the kind of case that falls in the gray zone, and when you're in the gray zone, the government wins.
I'm curious, what do you think about the threats in this case? Do you think they were serious enough for an asylum claim?
I think it's really in the gray zone. I think this is the problem when they talk about sort of bad facts make bad law, is this is the exact type of case where one judge would definitely grant asylum 100 out of 100 times, and another judge would never grant asylum 0 out of 100 times, because people just approach these cases with different levels of sympathy and different levels of concern and different standards in their mind of what constitutes persecution. And so the problem is, when you have such subjective, it's not AI deciding this case, it's people with their various levels of subjectiveness, and unfortunately, they bring their life experiences and preferences into the court system, and things that they've seen and perhaps other cases that they've heard in similar contexts, which they're not technically supposed to do. But, they're sitting there in immigration court and they're listening to hundreds of these cases a year. And so some of them start sounding similar, and they start then either sounding more sympathetic or less, depending on how many of these you hear and what you're hearing on different days. And so because all of that's happening, it really does become problematic in terms of the subjectiveness of the process. But what the Supreme Court's trying to figure out is, where does the subjectiveness stop? Does it stop at the Court of Appeals, or does it stop at the administrative level? And it seems like they're going to stop it at the administrative level for the most part, and not bring in sort of a new antiseptic Court of Appeals who's just reading a transcript without any other context and deciding, is this sufficient persecution? It didn't really seem like any of the Supreme Court justices wanted to do that de novo.
What's happening as far as the Trump administration's position on granting asylum?
Well, after this horrible attack on the National Guard, where one of them has passed away and the other is clinging to their life, the Afghan foreign national who had come in during the withdrawal from Afghanistan, and then he subsequently got asylum because he wasn't able to get what's called a special immigrant visa due to various timing issues. So this individual ends up getting asylum. And so because of that, the Trump administration has said that the asylum system needs an overhaul in terms of the way in which people applying for asylum are being scrutinized. So at the moment, there's currently a pause, meaning the entire country, nobody who's applied for asylum is going to get a decision. Now, interestingly about that is also nothing in immigration is simple, because somebody might say, oh, well, that's a simple solution. Just hold all these cases in abeyance and no one will get asylum and we won't have this problem. But, nothing is simple like that. There's always two sides to every coin. And the point is, these human beings are here. So it's not like they're sitting in some other country and you're holding these cases in abeyance. When someone applies for asylum, the number one criteria of being able to get asylum is that your body is here in America. So they're here already and they're applying. And so if you hold their case in abeyance, sure, there's some people who won't get the protection of asylum. That's certainly better than not having it. But there's a lot of other people who you might have wanted to deport and get them out faster, who you're not doing that because you're holding all the cases in abeyance and you're not making any decisions. So from that standpoint, I don't think this is a long-term or durable solution. Now, they may do something else and they may try to figure out some way to have a blanket denial of all asylum claims, but I don't think the courts are going to let them do that. And so I think this is just an effort to sort of punt this for as long as possible until some other solution can be done to limit the way and number of people getting asylum. But just a pause in and of itself definitely has these conflicting outcomes, because yes, people don't get asylum when you have a pause, but also people who have no business staying in the country get to stay longer because their cases remain pending.
Let's turn now to these arrests that immigration officials are making. So D.C. federal judge Beryl Howell ruled that U.S. officials have to stop enforcing this policy of conducting warrantless civil immigration arrests without probable cause to believe an arrestee is likely to escape before officials can obtain an administrative warrant. I mean, that's basic law, isn't it? That you can only make an immigration arrest without a warrant if the individual is violating an immigration law or is likely to escape before agents can get a warrant?
So this is a very tricky issue because This is about a policy as opposed to an actual police officer doing something. So what do I mean by that? What I mean is, if a police officer is just observing in the middle of or an ICE officer, let's be more precise about this. If an ICE officer is just observing in the middle of their daily operations of what they're doing at ICE, they're serving a warrant here, they're looking at an investigation here, and they happen to see somebody crossing the border illegally or something like that happening right in front of them, they can arrest that person. They don't need a warrant. They don't need probable cause of escape risk or anything like that. They're allowed to make that arrest because they're observing an immigration violation in front of them. What's complicated about this D.C. District Court case is they're saying that's different than having a policy in place that is saying, hey, ICE, go around and create a mass enforcement effort that does not require warrants. Just go around and start basically asking people about their immigration status and start arresting people anytime you see anyone that looks suspicious to you. So the issue in this case is whether a policy like that can be put in place. Now, the administration would say it doesn't have a policy like that, and then there's the words about the arguments about, well, that's what the leaders are articulating as the policy, so that it becomes a de facto policy, that's what that you're trying to accomplish. So the court says, fine, that is a policy that is had, where the administration, whether there's a piece of paper or not that says it, has this policy of saying a civil immigration arrest can be done without having a probable cause determination of escape risk. And so is that legal or not? And this has actually come up in other places. It's come up in LA, it's come up in Chicago. And in all these places, the district courts have held that what ICE needs to be doing is every day going through a list of people that it knows has undocumented status and going and finding those people, whether it's at their work or at their home or wherever, but not just sweeping around, looking around, saying, oh, this person looks weird, go find them. Now, the complication is, and so by the way, so what happens is in the district court here on December 2nd, issues a injunction saying, no, you can't do this anymore. You now need to have probable cause that the person is both unlawfully present and likely to escape, and you need a warrant to do these arrests. So it's basically back to what the Los Angeles court held and the Chicago court held, is you need to have a list every day of undocumented people that you go and apprehend. Or you need to have a police officer who's actually looking at something, not pursuant to a policy, but just is doing their job at observing some immigration crime happening. Yes, they can make an arrest. They don't need to go get a warrant to do it. But otherwise, you can't just have these sweeping patrols. The problem is, Justice Kavanaugh has already held in a case involving the Los Angeles issue that there can be these arrests. You know, they're sort of called now Kavanaugh stops, where you can have these sort of inquiries that ICE is making if they feel like this is the kind of situation where normally undocumented people are in a particular location, or there's some intelligence that they hang out at a particular place or do a particular thing. You could make these quote-unquote Kavanaugh stops. So I think that as this case goes up to the D.C. Circuit and back to the Supreme Court, it will probably run up against the same problem where the Supreme Court has already said that they can, with reasonable suspicion, start asking people about their immigration status.
And that decision was made on the emergency docket without full briefing or oral arguments. Thanks so much, Leon. That's Leon Fresco, a partner at Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.